Hi everyone, welcome to ITLS Academy. I am Advocate Priyanka, and as promised in my previous session, I am here with another IP topic. So, in our previous session, we discussed about the IP and IPRs, that is IP related rights in general. But now, in this session, we will specifically talk about some specific IP right, that is trademark. So, for today's session, our topic is Introduction to Trademark and Indian Trademark Act 1999. So, for this session, I have divided my topic in few subtopics like what is trademark, then types of trademark, and then we will move to the Trademark Act, that is trademark law, Indian trademark law. But before going to the current Trademark Act, which is already active, we will see that how it originated. So I have put one topic, that is origin of Indian trademark law. And then after that, we will go to the Indian Trademark Act 1999. In this, we will see some important sections, chapters, and then we will also see the international legal framework of trademark. And obviously, when we talk about something in too broad, we will know that what is the importance of that particular thing. So here we are talking about the trademark and their acts, rules. So here we will at last see that what is the role or what is the importance of trademark. So let's start. So we will go to our first subtopic, that is what is trademark. Here we can see clearly that trademark is basically made up of two independent works, that is trade and mark. So we will describe a very little about the trade and mark. I told here little because I think everyone knows that what is the trademark and what is the mark, but still we will see that. So first we will see that what is the trade. Here in this picture you can see one person who has groceries item, vegetable items. So that means he is the shopkeeper and he is selling same thing to the others. So that is basically the trade. Trade is basically transfer of service or goods. So here he is doing service of goods from one entity to other entity. So you can say that if some fruit seller is selling fruits to customers, so he is doing trade of fruits like this. Now we will see that what is the mark. Mark is basically a broad word which can be understood in different manners. Like someone can understood mark as some signs on your body or something. But overall, we can see that mark is that thing which is making that particular thing on which it is available from the others or other things. So here we are talking about mark in the context of trade. So here we can see that mark is basically a visual impression to distinguish or describe something. Like here I have told we are talking about the trade. So in first picture, that person is selling products, or maybe he is providing service for the same also, like he has some delivery boys and he is sending these products to other customers. So big basket, it is a well-known mark that is available for the same thing, that because big basket provide us the service for grocery items, vegetable item, and other items also I think they have included. So this is basically the mark that is distinguishing them, or that is describing them, that what they are doing, or that is distinguishing them from the same service of doing other entities. Like if any other entity is also doing the same thing, like delivery of groceries, products, and anything else in the same category of big basket, and big basket is also doing the same thing. So here this logo and this name Big Marks Basket is making them different from the other person which is doing or which is providing service in the same field. So now I think everyone has clear understanding of that what is trade and what is mark, for which specifically we are talking about in this session. So trademark is basically a recognizable word. Here recognizable word means that it gives a recognition, like big basket. Here this mark or trademark is giving a recognition to that particular entity. So this is a recognizable word, and this can be word, symbol or French, anything that to distinguish a specific product or service from other products or services of the same group, as I described just now. So as I told or in my previous session, that any IP related right, that is intellectual property rights, cannot be registered for the unlimited period. It can be registered for the definite period. Obviously for some rights that definite period is completely definite, but some rights if you are registering it for the some time, then you can do also renew that period of time. So here for trademark, it can be registered in India for 10 years from the date of filing of application. Here, like I also want to clear like that previous session that it's don't confuse with the registration period, or you can say the protection period. Like here it is registered in India for 10 years from the date of filing of an application. That means if any person or any entity is filing a trademark for their product or for their service today, and they are getting a certificate for that trademark even after 1 year or 2 year or 6 months, it depends, then their protection term will not be the date, will not be the will not be counted from the date of getting certificate. It will be counted only from the today's date, on which date they have filed the application. So I think it is clear now. So it can be further renewed after 10 years, and it can be renewed for an indefinite periods, but they have to pay some specific fee, and obviously there is some time period in which you have to give application for the renew. So we will see these things in detail in our next session. Now here, so now we have seen in our previous slide that what is mark and what is trademark. So I will give you some example of types of mark, or we will see that what are the types of mark basically. And here mark, as I told, we are talking in the context of trademark only. So there are basically two types of mark. First is trademark and second is service mark. So trademark is a mark that is basically representing any product, like you can say Puma shoes, new Nike shoes. So these are the basically representing mark for that specific shoes. Now here we are seeing that there is another mark, that is service mark. So service mark is not representing or not distinguishing any product. They are distinguishing any service, like Uber. So Uber has no particular car or not. We don't see Uber cars in market like Mercedes and BMW mini cars. So here we can see that Uber is basically providing the service for the transportation. So he is not providing the product, he is providing the service. So this is the service trademark. Now, as we discussed, what is mark? it was two type of trademark and service mark. Now we will discuss that what is the trademark. Here I want to clear one thing, that in general we say that trademark and service mark collectively as the trademark. So here we can see that type of trademark in context of collectively. Here I'm not uh, here I'm not going to tell that it will be the only service mark or it will the type of any trademark. It is basically the types of trademark. So first is conventional and second is non-conventional. So conventional, as its name is only telling that conventional is basically which we have been using since so many years, or which is in practice since so many years. So there are three types of conventional trademark: word, logo, and phrase. Any word that is describing that particular service or particular trade, any logo, or it can be any phrase or slogan. Here in this picture we can see Adidas. So Adidas, this word is basically the word trademark that is distinguishing this product. Now we can see this symbol with three lines. So this is basically the logo of Adidas. So this is logo trademark. Here in MACD we can see there is one phrase, or you can say one slogan, that I am loving it. So this is the basically phrase or slogan trademark. Now another one is non-conventional trademark. So non-conventional are basically which has been not practiced in since so many years, but it came practice recently or before some years, you can say. So earlier only these three marks were getting noticed and these three marks were getting trademark. But in nowadays there are other marks also which can be used as trademarks. That is, first is sound. So any specific sound, any specific tone can be used as the trademark for any particular product or any particular service. So here I have given an example of the Nokia tune. So basically Nokia tune has some specific arrangement of their tunes or their music. So it can be basically, this tune is basically the sound trademark for that Nokia. Now we can see a smell. A smell is that fragments of any particular product. So here I want to make clear one thing, that this smell for getting trademark must be distinctive. It should not be the basic property of that product. So here just take an example that if we are talking about the perfume, some perfume have some other fragrance, some perfume have some other fragrance, but basic property of fragrance is to smell in any fragrance. So here a smell cannot be trademark for the any perfume. But yes, if any product which has not that basic property, that is getting a smell, so here they can get product. Here I have taken one example of Brazilian manufacturers which make shoes and footwears. So basically they use a specific smell or a specific scent, you can say, that is bubble gum for their products. So smelling in a different way or like in a some specific way is not the basically property of shoes or footwears, but here they are providing this. So this is making them a recognition. That's why bubblegum scent for shoes and footwears are trademark scent for this Brazilian manufacturer. Now we are talking about the color. So color, that can be one color or combination of more than one color, can be also get registered for the trademark. Here we can see FedEx. So FedEx is the word which is registered trademark for courier company. So here we can see that it is made up of two combination of colors, Fed and X. Fed is in blue or purple, I think, and then X is in orange. So this color combination with that product is their trademark. Now we will move to the origin of Indian trademark law. So nothing came in existence which is in the present condition, so that it's not that that was also in their past. So we can take simple example of ourselves. So like if anyone is doctor or anyone is advocate, anyone think, so he is not that from the starting, they have originated to that. So that means earlier they were something else. Here also it's like for the trademark law. There, what is the active trademark act right now? It is not the only trademark act which was active previously also. So there were some points from where they originated and developed to current trademark act. So before 1940, you can say that there was no specific law for the trademark in India. It was basically based on the common law principle of passing and equity as followed in England. Obviously, we were that time we were ruled by the England, so we were following the rules of England. Now, we can say that first statutory law related to trademark in India came in existence in 1940. That was the Trademark Act 1940. It was also based on the UK rules, that was UK Trademark Act 1938. Now, after that, it developed into the Trademark and Merchandise Act 1950 Act. It came in existence like some other acts of India, like Indian Penal Code, Indian Criminal Code, like this type of things. And after passing different stages, we got the Trademark Act 1999. It replaces the Trademark and Merchandise Act 1958. And this is the Trademark Act which is currently active and which is currently governing laws for the trademarks in India. So now we will see that what are the basically Trademark Act 1999, what are their objective, and we will see the some important sections also, because here in this short video we cannot explain because it is act of our constitution, so we cannot explain every act, every sections, but obviously I will go through the some important sections. So here first we will see that the Trademark Act 1999 is basically regulating the application process of registration to protection of registered mark. So if we are going to apply for the registration of any particular mark and we are getting that registration, all things are governed by the Trademark Act 1999. It also deals with the prevention of fraudulent use of trademarks, that you can say. It also deals with the, in common word, infringement of trademarks. So if anyone has infringed some other trademark, we have some rules and some sections in our Trademark Act 1999 for that also. This Trademark Act 1990 is basically comprised of 13 chapters, which includes 159 sections. So as I told, I can't describe all sections here, but we will see some few important sections. So first section is section 1, that is short title, extent and commencement. So it is basically gives an idea or gives the rules, what are the short titles of some things, different things. Now second is section 2, that is giving the definition and interpretation of used every word in Trademark Act. So if we take example of the trademark, so from where we got that definition? We got that definition from the section 2. So according to section 2ZB, trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of other in the same service, and it includes shape of goods, their packaging and combination of colors. So this is the basic definition of trademark from which we are deriving our own definitions for the trademark. Like this, Section 2 is giving definition for each and every term used in the Trademark Act. Now section 3. This act is basically defining the appointment of registrars and the officers. So you can basically say that it is defining that who are basically uh, you can say that who are basically regulating these acts. Or so here, Controller General of Patents, Design and Trademark. He is the one who is the same for patents, design and trademark, and he is the, you can say that first, you can say that he is that person which is looking over all these rules and regulations, and he is appointed by the central government. The central government appoints other officers also. Obviously there will be no only controller general, there will be some other officers also. So they appoint or they suggest to the controller general about the other officers, and it is done under the supervision of registrar. Now section 7, classification of goods and service. So this section is basically defining that okay, just take an example, like I am selling some food and anyone is doing the food service. So it will both come in the food categories, or someone is selling in the medicine, or someone is doing research. So these all things will become in different categories, and according to category they will get the registration certificate for that trademark. So these categories are basically defined in section 7. In India, trademarks are classified in 45 categories, and obviously they are following with many subcategories like I told, food, medicine, patent, etc. Now section 9, it is also an important or you can say very important section for the Trademark Act. So basically it gives absolute grounds for refusal of registration. Like if you are going with an application, so you will have to see these things, otherwise your application will get rejected. So first, if any application is deceiving the public or likely to create confusion, like if there is other trademark already and you are making like same trademark with some differences which may confuse to the public, that will be refused. So here we can see one example, that is Puma. It is the word along with this, but this is created by myself. So I have taken this Puma, and upper to that this is horse. So do you think it is the same? No, but in first instance, if anyone will see, they will think, yeah, these both are the same. So that means they are selling, they have the same brand. So this is basically deceiving the public or creating confusions among them, that who is the original Puma, or both are similar. So then in this case, it will not get grant for the registration of trademark. Now, another more thing is also that any matter which is likely to hurt religious emotions. As we all know, in India, we are secular. We have people of all religions, and we value and give respect to all religions. So anything, if you are making which has the sign or words or anything which is hurting any particular religion, that will be not get registered. Here you can see that if you are using any these type of signs or anything on your product or on your service, then that particular sign or that particular word will not get registered. Now section 11, it has also some relative grounds for refusal of registration. So it is basically for one example we can see that it is identical with an earlier trademark and similarity of goods or service covered by the trademark. So it is also like something like section 9. You can see that Starbucks, everyone knows that Starbucks is basically the coffee shop brand. So here we can see there is another. It's not created by me. It's already infringement case was filed by Starbucks on this. So this is Starbucks coffee and co- so these both are working in the same field, that is coffee shop, and this is making confusion to some extent also. So here this will not get registration, and in case if they have got registration or they have not done registration and they are using this, because in India for the trademark it's not necessary that you go for the registration, but obviously if you went for the registration you will have the protection. So even you are not registered, you are using this, you will be get sued from the original owner, like here Starbucks did for this. Now section 13. So provision of registration of names of chemical elements or international non-proprietary names. So in our Indian Trademark Act, we cannot register name of any chemical element, just like ethyl alcohol, methane, or anything chemical element, and some international non-proprietary names also. So here first we need to know that is what is this. So international non-proprietary names are basically pharmaceutical substances or active pharmaceutical ingredients which is basically published, that will be used over the worldwide same. So we cannot go directly for the registration of that active ingredient or that active pharmaceutical product, just like paracetamol. It is an international or property name. So we cannot and we or anyone cannot make any medicine like the brand name of paracetamol. So here every paracetamol have the same active ingredient, that is paracetamol, but they have different names like Paracet 500. So here we can see these are Paraceta tablets, but they have not given the name paracetamol. So they have given the name Paracet. Other can be Crocin also. So basically here if anyone goes for the name of paracetamol for their trademark registration, they will get refusal. Now section 14. So it is basically the use of names and representation of living person or person recently dead. Here that cannot be get registration. Here you can see that living person's name, obviously persons which are very familiar, which are very famous. So we cannot use their names as our trademark product. Like Mahindra and Mahindra Paper Mills Limited versus Mahindra and Mahindra Limited. Here Mahindra and Mahindra Limited is a well-known company, but after few years, or you can say after many years, Mahindra and Mahindra Paper Mills Limited come in existence, which was not over at all the part of this Mahindra and Mahindra. Then Mahindra and Mahindra filed infringement case on this. So in this case, court gave decision in favor of Mahindra and Mahindra, because court told that Mahindra name is the basically a name of quality and name of assurance for the public. So it cannot be used by others because it will give confusion to public that it is overall related to this Mahindra and Mahindra. So court gave decision in favor of Mahindra and Mahindra Limited only. So we can see that before using any name or any representation of a person who is living or who is dead, we will have to check sorry that is it registered or is it name of any person who is very popular. And then after seeing all the requirements only we can go for the registration of that particular. Now section 18, it is the application for registration. So it is basically for the, if you are going to file the any mark as a trademark, so for that application we have to follow the rules according to section 18. Then section 25, which is basically giving the rules about the duration, renewal, removal and restoration of your trademark or service mark registration. Then section 29, it is basically the infringement of registered trademarks, like in Mahindra and Mahindra case. So if anyone is infringing any other trademark, they will go to the section 29 and then they can see that what are the remedies or what can be done. Now there is section 36D. It is for the international application originating from India. As I discussed in my previous session that IP rights can be registered nationally and internationally as well. So here trademark can be also registered internationally. For that we will have to file the international application, and for that we have rules in the section 36D. Now section 36G, which is giving the basically duration and renewal of international registration. So here it is also the period of 10 years, and it can be again renewed for the 10 years from the expiry of the preceding, like we got protection from today to 10 years. So when 10 years is getting expired, previous to that we will have to file another renewation for the same product, if you same mark, if you want to protect for the 10 years. Now section 45, that is the registration of assignments and transmissions. So basically if we have some well-known brand and some others wants to use that, obviously in the supervision of our quality assurance, then they will have to do, or we will have to do registration for that also, that is registration of assignments, and if we are giving to some others for the transmission. So this all rules will come under section 45. Now section 47, it is basically in Trademark Act, it is the rule that if there is any trademark which we got registered and which are not using that overall, so on that basis it can be removed, or registrar can put some limitations on use of that trademark. So it comes under the section 47. Now section 135, it includes the relief in suits for infringement or for passing off. Just like we have seen that we have provision to file infringement case for over the infringers, like that there are some provisions also that how any infringer who is who was not doing it intentionally, or he wants some other remedies, so this type of things can be provided in section can get in section 135. Now section 156, so it is basically the power of central government. So basically this Indian Trademark Act or their main office, these are basically under the control, or you can say under the supervision of central government. So central government have power to remove difficulties also if there's some difficulties comes in the in like uh, following the rules or implementing the implementation of rules. So this central government have power to remove that difficulties. Now the last one is it's not last one, but it's last one in my list. It is the section 157, that is power to make rules. Like central government have power to remove difficulties in rules or implementation of rules, central government has power of making rules by notification official gazette also. So they can make rules as per the situation or requirement. Now there are some international legal framework of trademark law. Like in our previous session, we saw that there is international legal framework of IP law. So it's a very correlated to that. earlier we have seen that what is the Paris Convention. So it is basically the protection for trademark, patent, industrial property, all. So through the Paris Convention we get the protection for trademark also. Now TRIPS agreement. So basically it binds WTO members, that is World Trade Organization member, and India is also a country for the same, for further rules and obligations for intellectual property rights in general and addresses trademark law. So what can be minimum criteria for any trademark law which is going to implement in any national? Now Madrid Agreement or Protocol. So through this protocol we can file one mark to one country to various countries, different countries. So basically it governs the system for international registration of marks. Now NICE agreement. So it is basically the international system of classification of goods and services. Like we saw in our previous slide that there is a classification system for every trademark, and in India we have that 45 categories following with many subcategories. So here also that type of classification for the international system. So for when we are filing internationally, we have to look for that. First, we have to look for that system of classification, that in which group our product or service is following. Now, basic principle of international legal framework. It is basically the same for the all IP rights. So it is the national treatment. Like if anyone is filing any mark from India to other European country or other any country, then they will must follow the same rules, or they will must apply the same rules for an Indian like their own citizens. There should be no any difference. So this is basically the national treatment. Now minimal requirements for national obligation, as I told, TRIPS gives the basic standard requirements for trademark law. So uh, so it is the benefit of international agreement. You can say that no one can just force any country to put more laws than which are the already given in the TRIPS. So they can do according to their own nationals. They can keep same, or they can do some less. So it depends on the country to country, and it's applicable to a state versus a state only. So like if any Indian applicant is filing any application to any other country like Sweden, so it is not like that application is to that Indian person versus Sweden. It is Indian. It is basically for the India versus Sweden. So it is versus state versus state only. It's not individual versus state or individual versus individual. Now, after going through these all points about the trademark and trademark act, obviously we will eager to know that why are we uh, going through these all things, what is the basically importance of that trademark. So I think it is overall clear with the previous slide, but here I have gathered some few points to clear more this, that basically it defines the product and its origin. Here I have taken one example of you can say color, that is L'Oreal company. So if we are buying this product either in India or either in Belgium or any country, the origin for this will be the same, that will be the L'Oreal company. Second, it guarantees quality of the product. So whatever quality for this product we are getting in India, we will get same in other countries also. There will be no difference. This is the main you can say benefit or importance of the trademark, that it assures the quality. Now it distinguishes same type of products like we described in our first slide also and in mid also. So if here we are taking an example of lavender oil. So here this lavender oil is from the another from the some company, that is Tuasa, and this is from the Himalaya. Both are lavender oil, but this uh, word mark, that is Himalaya, and here this Tuasa. This is making difference among them, that this belongs to that particular and this belongs to that particular. So this is basically giving the recognition to their to the product of a particular entity. If here we see that we have two bottles for essence oil, which simply written oil or essence oil, this and this, so there is no difference, both are the same. How will we decide that which includes to which relates to which entity, or which relates to which entity, or which is the which has the good quality for you, or which you don't like? So it will give the confusion, or not confusion, overall you will not get any idea about the confusion is a different thing. You will not get the any idea about the product or about the entity uh, who is making that particular product. So this is the you can say this is the main function of the trademark, which is uh, which is to give the recognition or to distinguish from other products. So it was overall the trademark. We cannot say that overall about the trademark. Some few topics about the trademark. So now I think are you all will be curious to know. So am I right? Are you curious to know about that? How can we select suitable mark for registration of trademark? As I told, there are so many rejections grounds, and if we are we have selected some suitable marks, then how will we see that our trademark is going to other infringe other trademarks? Or if you have already well established trademarks, then how will you uh, see that, or how will you search that others are infringing your trademark? And if you found suitable trademark, and you found that your trademark is not going to infringe other trademarks, then what to do next? How will you go for the registration? So all these topics, for with all these topics we are coming in next sessions. So to get answers about your this curiosity, please subscribe to us, and please keep tuned. Thank you for watching, and please follow ITLS Academy on Insta, Facebook, LinkedIn, everywhere, and you can even get it on the Google Play also. Thank you so much for the watching.